Rule 3122A. Certification of business records. Business records produced pursuant to a subpoena duces tecum under Rule 3120 shall be accompanied by a certification, sworn in the form of an affidavit and subscribed by the custodian or other qualified witness charged with responsibility of maintaining the records, stating in substance each of the following. 1. The affiant is the duly authorized custodian or other qualified witness and has authority to make the certification. 2. To the best of the affiant's knowledge, after reasonable inquiry, the records or copies thereof are accurate versions of the documents described in the subpoena duces tecum that are in the possession, custody, or control of the person receiving the subpoena. 3. To the best of the affiant's knowledge, after reasonable inquiry, the records or copies produced represent all the documents described in the subpoena duces tecum, or if they do not represent a complete set of the documents subpoenaed, an explanation of which documents are missing and a reason for their absence is provided. And 4. The records or copies produced were made by the personnel or staff of the business, or persons acting under their control, in the regular course of business, at the time of the act, transaction, occurrence or event recorded therein, or within a reasonable time thereafter, and that it was the regular course of business to make such records. B. A certification made in compliance with subdivision A is admissible as to the matters set forth therein, and as to such matters shall be presumed true. When more than one person has knowledge of the facts, more than one certification may be made. C. A party intending to offer at a trial or hearing business records authenticated by certification subscribed pursuant to this rule shall, at least 30 days before the trial or hearing, give notice of such intent and specify the place where such records may be inspected at reasonable times. No later than 10 days before the trial or hearing, a party upon whom such notice is served may object to the offer of business records by certification stating the grounds for the objection. Such objection may be asserted in any instance and shall not be subject to imposition of any penalty or sanction, unless objection is made pursuant to this subdivision, or is made at trial based upon evidence which could not have been discovered by the exercise of due diligence prior to the time for objection otherwise required by this subdivision. Business records certified in accordance with this rule shall be deemed to have satisfied the requirements of subdivision A of Rule 4518. Notwithstanding the issuance of such notice or objection to same, a party may subpoena the custodian to appear and testify and require the production of original business records at the trial or hearing. D. The certification authorized by this rule may be used as to business records produced by non-parties whether or not pursuant to a subpoena, so long as the custodian or other qualified witness attests to the facts set forth in paragraphs 1, 2 and 4 of subdivision A of this rule. 3123. Admissions as to matters of fact, papers, documents and photographs. Notice to admit, admission unless denied or denial excused. At any time after service of the answer or after the expiration of 20 days from service of the summons, whichever is sooner, and not later than 20 days before the trial. A party may serve upon any other party a written request for admission by the latter of the genuineness of any papers or documents, or the correctness or fairness of representation of any photographs, described in and served with the request, or of the truth of any matters of fact set forth in the request, as to which the party requesting the admission reasonably believes there can be no substantial dispute at the trial, and which are within the knowledge of such other party or can be ascertained by him upon reasonable inquiry. Copies of the papers, documents or photographs shall be served with the request unless copies have already been furnished. Each of the matters of which an admission is requested shall be deemed admitted unless within 20 days after service thereof, or within such further time as the court may allow. The party to whom the request is directed serves upon the party requesting the admission a sworn statement either denying specifically the matters of which an admission is requested, or setting forth in detail the reasons why he cannot truthfully either admit or deny those matters. If the matters of which an admission is requested cannot be fairly admitted without some material qualification or explanation, or if the matters constitute a trade secret, or such party would be privileged or disqualified from testifying as a witness concerning them, such party may, in lieu of a denial or statement, serve a sworn statement setting forth in detail his claim, and, if the claim is that the matters cannot be fairly admitted without some material qualification or explanation, admitting the matters with such qualification or explanation. B. Effect of admission. Any admission made, or deemed to be made, by a party pursuant to a request made under this rule is for the purpose of the pending action only, and does not constitute an admission by him for any other purpose, nor may it be used against him in any other proceeding, and the court, at any time, may allow a party to amend or withdraw any admission on such terms as may be just. Any admission shall be subject to all pertinent objections to admissibility which may be interposed at the trial. C. Penalty for unreasonable denial. If a party, after being served with a request under subdivision A, does not admit, and if the party requesting the admission thereafter proves the genuineness of any such paper or document, or the correctness or fairness of representation of any such photograph, or the truth of any such matter of fact, he may move it or immediately following the trial for an order requiring the other party to pay him the reasonable expenses incurred in making such proof, including reasonable attorney's fees, unless the court finds that there were good reasons for the denial or the refusal otherwise to admit, or that the admissions sought were of no substantial importance. The order shall be made irrespective of the result of the action. Upon a trial by jury, the motion for such an order shall be determined by the court outside the presence of the jury. Rule 3124. Failure to disclose, motion to compel disclosure. If a person fails to respond to or comply with any request, notice, interrogatory, demand, question or order under this article, except a notice to admit under Section 3123, the party seeking disclosure may move to compel compliance or a response. Rule 3125. Place where motion to compel disclosure made, unless otherwise provided by rule of the Chief Administrator of the Courts. The county in which a deposition is being taken or an examination or inspection is being sought may be treated by the moving party as the county in which the action is pending for purposes of Section 3124. Rule 3124. Failure to disclose, motion to compel disclosure. If a person fails to respond to or comply with any request, notice, interrogatory, demand, question or order under this article, except a notice to admit under Section 3123, the party seeking disclosure may move to compel compliance or a response. Rule 3126. Penalties for refusal to comply with order or to disclose. If any party, or a person who at the time a deposition is taken or an examination or inspection is made is an officer, director, member, employee or agent of a party or otherwise under a party's control, refuses to obey an order for disclosure or willfully fails to disclose information which the court finds ought to have been disclosed pursuant to this article, the court may make such orders with regard to the failure or refusal as are just. Among them, 1. An order that the issues to which the information is relevant shall be deemed resolved for purposes of the action in accordance with the claims of the party obtaining the order. Or 2. An order prohibiting the disobedient party from supporting or opposing designated claims or defenses, from producing in evidence designated things or items of testimony, or from introducing any evidence of the physical, mental or blood condition sought to be determined, or from using certain witnesses, or 3. An order striking out pleadings or parts thereof, or staying further proceedings until the order is obeyed, or dismissing the action or any part thereof, or rendering a judgment by default against the disobedient party. 3130. Use of interrogatories 1. Except as otherwise provided herein, after commencement of an action, any party may serve upon any other party written interrogatories. Except in a matrimonial action, a party may not serve written interrogatories on another party and also demand a bill of particulars of the same party pursuant to Section 3041. In the case of an action to recover damages for personal injury, injury to property or wrongful death predicated solely on a cause or causes of action for negligence, a party shall not be permitted to serve interrogatories on and conduct a deposition of the same party pursuant to Rule 3107 without leave of court 2. After the commencement of a matrimonial action or proceeding, upon motion brought by either party, upon such notice to the other party and to the non-party from whom financial disclosure is sought, and given in such manner as the court shall direct. The court may order a non-party to respond under oath to written interrogatories limited to furnishing financial information concerning a party, and further provided such information is both reasonable and necessary in the prosecution or the defense of such matrimonial action or proceeding. (3131) Scope of interrogatories. Interrogatories may relate to any matters embraced in the disclosure requirement of Section 3101 and the answers may be used to the same extent as the depositions of a party. Interrogatories may require copies of such papers, documents or photographs as are relevant to the answers required, unless opportunity for this examination and copying be afforded. 3131. Scope of interrogatories. Interrogatories may relate to any matters embraced in the disclosure requirement of Section 3101, and the answers may be used to the same extent as the depositions of a party. Interrogatories may require copies of such papers, documents, or photographs as are relevant to the answers required, unless opportunity for this examination and copying be afforded. Rule 3132. Service of interrogatories. After commencement of an action, any party may serve written interrogatories upon any other party. Interrogatories may not be served upon a defendant before that defendant's time for serving a responsive pleading has expired, except by leave of court granted with or without notice. A copy of the interrogatories and of any order made under this rule shall be served on each party. Rule 3133. Service of answers or objections to interrogatories. Service of an answer or objection. Within 20 days after service of interrogatories, the party upon whom they are served shall serve upon each of the parties a copy of the answer to each interrogatory, except one to which the party objects. In which event the reasons for the objection shall be stated with reasonable particularity. B. Form of answers and objections to interrogatories. Interrogatories shall be answered in writing under oath by the party served, if an individual, or, if the party served is a corporation, a partnership, or a sole proprietorship, by an officer, director, member, agent, or employee having the information. Each question shall be answered separately and fully, and each answer shall be preceded by the question to which it responds. C. Amended answers. Except with respect to amendment or supplementation of responses pursuant to subdivision H of Section 3101, answers to interrogatories may be amended or supplemented only by order of the court upon motion.
H. Amendment or supplementation of responses. A party shall amend or supplement a response previously given to a request for disclosure promptly upon the parties thereafter obtaining information that the response was incorrect or incomplete when made, or that the response, though correct and complete when made, no longer is correct and complete, and the circumstances are such that a failure to amend or supplement the response would be materially misleading. Where a party obtains such information an insufficient period of time before the commencement of trial appropriately to amend or supplement the response, the party shall not thereupon be precluded from introducing evidence at the trial solely on grounds of noncompliance with this subdivision. In that instance, upon motion of any party, made before or at trial, or on its own initiative, the court may make whatever order may be just. Further amendment or supplementation may be obtained by court order.
3140. Disclosure of appraisals in proceedings for condemnation, appropriation, or review of tax assessments. Notwithstanding the provisions of subdivisions C and D of Section 3101, the Chief Administrator of the courts shall adopt rules governing the exchange of appraisal reports intended for use at the trial in proceedings for condemnation, appropriation, or review of tax assessments.
The fucking chief administrator shall adopt rules governing the exchange of appraisal reports intended for use at trial in proceedings for condemnation, appropriation, or review of tax assessments.
Objections to interrogatories. Service of an answer or objection. Within 20 days after service of interrogatories, the party upon whom they are served shall serve upon each of the parties a copy of the answer to each interrogatory, except one to which the party objects. In which event the reasons for the objection shall be stated with reasonable particularity. B. Form of answers and objections to interrogatories. Interrogatories shall be answered in writing under oath by the party served, if an individual, or, if the party served is a corporation, a partnership, or a sole proprietorship, by an officer, director, member, agent, or employee having the information. Each question shall be answered separately and fully, and each answer shall be preceded by the question to which it responds. C. Amended answers. Except with respect to amendment or supplementation of responses pursuant to subdivision H of Section 3101, answers to interrogatories may be amended or supplemented only by order of the court upon motion.